Hi students, today we're going to look at a case Riggs et al. Versus Palmer. Again, this is another old case from 1889. Again, the case is going to help us better understand the difference between legal positivism and natural law theory. Before we get into that case, however, I want to just review a bit about those two theories, legal positivism and natural law theory. So legal positivism is the view, as we said last time, that the existence and authoritativeness or validity of law does not depend on moral facts or principles. It just depends on sort of social facts about what people do, how they interact. I've described this here as the view that the law is power view, and I think that's because for the positivists, what counts as law depends on something like who has the power to speak authoritatively, or who has the power to enforce the rules that they lay down. And so one way of thinking about legal positivism is just this view of the law as power. So let's look at some examples, right? John Austin said that the law is a command of a sovereign that's backed by force. And we looked at some reasons I think maybe that's not quite right. H.L.A. Hart will later say that the law is the union of primary and secondary rules. Of course, right here, it's not at all clear exactly what that theory means. But what Hart does basically is to sort out some of the problems with Austin's theory and Austin's discussion of commands of the sovereign. What Hart does is point out that, well, there are these primary rules like murder is wrong, murder is illegal, and there are these secondary rules about how murder could become illegal. So the secondary rules say something like, if this legislature passes this thing by voting, more than 50% of the people vote in favor of it, then it becomes a law. And so, when you don't have a sovereign per se, right, like a monarchy where there's one person at the top telling you what all the rules are, you need these secondary rules that sort of everybody looks to know when something becomes a law. Anyway, I don't need to get in the weeds there. The thing that maybe these views share in common is this idea that the existence of law is one thing, its merit or demerit another. So, is there a law? That's one question. Is it a good law? Is it a bad law? That's another question. The positivists sort of say that the natural law theorists confuse those two questions and turn them into one. That whether or not something is law depends on its merit or demerit. And they think that's a mistake. So that takes us to natural law theory, right? Natural law theorists don't see the law as being depending on power, the law is power, rather they see the law as depending on its being just. So the law is justice here. So on their view, the existence and authoritativeness or validity of law does depend on moral facts or principles. So we get a definition from Aquinas that says law is nothing else than an ordinance of reason for the promotion of the common good made by him who has care of the community and promulgated. So we've got 4 criteria. Again, the maybe central one that sort of makes this a natural law theory is this idea that law has to be an ordinance of reason, but more importantly, that it's got to promote the public good. If it doesn't do that, the thought is that it's not law. St. Augustine actually becomes before Aquinas, but says an unjust law is no law at all. That claim sort of speaks to maybe one, again, oversimplified maybe way of understanding what the natural law theory says. Okay, so we've got the law as power on the one hand, law is justice on the other hand, and we want to know which of these views is right. So that takes us back to the case, Riggs et al. Versus Palmer. this is going to be a really interesting case. Hopefully you read it already, but I'm going to describe some of the facts in case you haven't, and you can get sort of a bare bones understanding. Okay, so Francis B. Palmer owns a farm and a considerable amount of personal property, a lot of land, a lot of stuff. This guy is rich. Okay, so he wills some of that property, land, etc., to daughters, Mrs. Riggs and Mrs. Preston, but most of it he wills to Elmer Palmer, his 16-year-old grandson. Now, why exactly this is not like immediately obvious from the case. Maybe his like one daughter hasn't married. Maybe his one daughter has married. Maybe he's got a son married. I don't know. I don't get it. I shouldn't say I don't get it, but I don't know enough of the details to speak authoritatively. But whatever the case is, Francis Palmer is saying, like, Elmer Palmer, you're getting most of my stuff. My other two daughters, you're getting some of it. And that's when the problem arises. So Elmer, it seems like, is not maybe the best grandson and causes some problems for his grandfather. And so Francis threatens to remove Elmer from the will. But Elmer is like, I'm not going to get cut out of this will. And so he poisons his grandfather, killing him. Okay, interesting setup. Elmer thinks, I'm going to get this will. I can't let Francis change it, so I kill him. Okay. New York's legislature, and this case is taking place in New York. New York's legislature has passed laws that outline how wills are to be made, altered, and revoked. So here's the process for making a will. But New York's legislature hasn't passed a law that prohibits murderers from inheriting property from their victims. So New York hasn't really anticipated this kind of case happening. Like, here's how you make a will, here's, how you execute a will, here's how you want to change it, here's how you might revoke it. All those things. But, we don't really know what to do when someone kills someone else to inherit their stuff. So the legal question then is just, is Elmer Palmer, who killed his grandfather, entitled to inherit the stuff he was supposed to inherit? On the one hand, maybe this is apparent from just the facts. It's like, well, the law doesn't really say much about that. Seems like it's fine. But on the other hand, it seems like obviously problematic to let someone murder their grandfather to inherit from the grandfather. Now, one thing you might be wondering is, why does it matter? Elmer's going to be in jail for the rest of his life. But that's not really right. I think most murderers actually do get out after some period of time, and it'd be nice, it's nice for them to have some money. It's nice to have some money while you're in jail. So, again, maybe this, isn't the most pressing question in the world to you or whatever, but again, we're interested in a sort of philosophical question in the background. So, one thing, right, I encourage you to ask, how did the court rule? How do you think it should rule? If you read it, right, did you pay attention? Did you understand sort of what the court was saying? Did the court rule in favor of Mrs. Riggs and Mrs. Preston? Did it rule in favor of Elmer Palmer? Why did it rule that way? So, again, I'm not I'll need to think a little bit about whether or not I want you to read these cases before you look at the lecture or after. Maybe see what works for you. But if you read it already, right, reflect. What did the court say here? That's something you always want to be asking yourself when you're reading a court case. Okay. If you want to read it now, pause it, go do that. When you're ready, unpause it, and we'll continue on. Okay, so the majority opinion, right? The majority opinion, again, is the opinion of most of the justices. It's always given first. And in this case, there is a dissenting opinion, so we'll mention something about that a little bit. But the majority opinion rules that Elmer Palmer was not entitled to inherit from his grandfather's estate. So, no, Elmer, you're not going to get your grandfather's inheritance. This opinion was written by Judge Earl, and it argues that ruling in Elmer Palmer's favor would conflict with the intent of the legislature and the fundamental maxims of the common law. So there's sort of two different legal arguments that this judge is giving. One says when we want to look at what the law says, we need to look at what the legislature intended. The other argument saying when we're looking at what the law says, we need to look at sort of these fundamental principles that we see in past rulings. When we talk about the common law, they're talking about precedent. They're talking about cases that judges have ruled in earlier in the past. And they can see some fundamental maxims, some common principles there that lead them to think that Elmer Palmer shouldn't be able to inherit. The ruling also seems to suggest that ruling in Elmer Palmer's favor would conflict with morality or the moral law or the divine law. There's this idea that, come on, if we give Elmer this stuff, that's immoral. We're supporting immorality. It's immoral to give him this stuff. And so there's a problem there. Now, I think it's intuitive to see this view as a kind of natural law view, that when we've got these hard cases, when the law runs out, when I don't know what to say, we can use morality to arrive at the right position. We use something other than just like the statutes. We use something other than like, the rules that we've got laid down. We appeal to moral principles. We appeal to the intent of the legislature. We appeal to the moral law, something like that, to give the law, to fill out the law, to tell us what to do in the hard cases. When we look at the dissenting opinion, this is, I think, given by Judge Gray, it argues that Elmer Palmer was entitled to inherit. He is entitled to inherit his portion of the estate. So again, Judge Gray's opinion doesn't go into effect. He was not in the majority, so in a sense, what he says doesn't matter. It might be, again, picked up later by someone else who thinks there's a good argument here, but really it's just sort of a way for Gray to explain his thinking. And his central argument, in his opinion, is that since nothing in the literal or straightforward reading of the statute prohibits Elmer Palmer from inheriting, it would be inappropriate to rule against him. The thought is something like, well, we didn't warn Elmer that he was going to get in trouble if he did this thing. We didn't warn Elmer that he was going to lose the inheritance. And so I guess we've got to let him have it. The thought here being maybe that if the legislature doesn't want this to happen, they've got to go back and make a law that prohibits people from profiting from their own crimes. Now, the central philosophical question here, right, it's a question about between the natural law theorist and the legal positivist. But maybe to put that more specifically, it's a question about what does the law depend on, or what's the law constrained by? So when we're trying to understand what the law says, do we look just at a literal or straightforward reading of the statutes? That's one option. Maybe we should look at what the legislature intended. What was their intent when they made that law? Did they mean for someone like Elmer to inherit or not? Another thing, we might look to precedent, right? We look to the fundamental maxims. We look to the principles of the common law, what judges have said in the past. Or does the law depend on morality? Is it constrained by what's morally right or wrong? That's the philosophical question here. Which of those options are the right one. And if morality, right, if morality plays a role, and morality can play a role in a variety of different ways, but if morality plays a role, then maybe the law is something that maybe the law, its authoritativeness, validity does depend on moral facts or moral principles. All right. Before we look at the next video, I'm going to go into some of the details of the arguments that were made in this case. But before we do that, think about how you would rule. Would you rule in favor of Mrs. Riggs and Mrs. Preston, or would you rule in favor of Elmer Palmer? We're learning about how to give arguments and make arguments. I would encourage you, right? Give a valid argument in favor of your view. Figure out what your conclusion is. What's your reason? Can you give a deductively valid argument that gets from your reason to your conclusion? All right. Next time we'll be looking at some of the arguments that those judges made, and we'll read a little bit more about the case.